following is a production of Temple University Beasley School of Law.
Without further ado, Chief Justice Leo Strine.
Actually, I want to especially thank Jonathan because we arranged that elegant, lowering of the microphone by having him go in between. I also say if I admire Judge Posner, it is because of his intellect and his amazing productivity, which Cass Sunstein, I think, and Richard Posner produce astonishingly incisive things and sensible things in an amount of time, which is just incomparable. I do aspire, though, to one other thing I admire about Judge Posner, which is his hairstyle. I do want to make one correction, lest it be, I was not a summa cum laude graduate of my alma mater. I would be today because I believe that there are 55 summa cum laude graduates. But some of you may know Professor Rock. He is, like I was, a magna cum laude, and there were actually only a handful of us. There are 50 summa cum laude graduates of the law school at 3400 Chestnut Street. Then there's another 100 magnas, and then the rest are cum laude. And well, I would say about Delaware and class actions, there is some skepticism in Delaware class actions. I think you will find that there is no court system in the nation, including the federal court system, that has actually delivered more real remedies on behalf of classes and the people who are in classes. I think the skepticism, to the extent it exists, is when there's a concern that the folks who are represented don't get something out of it. And that's a fitting thing to my, the actual things I've written down, because I am extremely honored to be asked to give this inaugural Harold E. Kohn Lecture at this distinguished law school, and I'm honored to have his son here, who is an accomplished advocate in his own right, and to have him sitting next to one of the both most respected and feared advocates on the plaintiff side in the country, in Len Barrick. Harold Kohn was one of the last century's most accomplished lawyers, a master of complex litigation, a vigorous advocate for civil liberties, and he was a graduate of my alma mater. And so it is a profound honor to deliver this lecture. I decided to honor the spirit of this lecture series by focusing my minutes with you on a subject that my experience as a judge might qualify me to discuss. In a setting like this, someone like me can be most valuable by not pretending, that he's skilled at regressions or the like. People may consider me to be, something that's gone backwards in Darwinian terms, but and that's their own label. But I don't claim to do reductive exercises in statistical modeling of complex human behavior and to draw insights from 18-month observations. I leave that to more learned people like some of my friends in academia, most of whom are not my friends in academia aren't here. Most of the academics here who are here today, I think, take a more complex, nuanced look at human behavior. I also want to say to the contract students in the back row, I hope that there's their club seats. I think they come with refreshments later. Pay attention in contracts. I will say, though, that one of the mandatory courses that should be required in law school is complex agreements, a second contracts class. Make sure you seek out the equivalent. I don't care whether you're going to be an environmental lawyer. I don't care whether you're going to be a litigator who negotiates settlement agreements. I don't care whether you're going to be a trust and estates lawyer. There is no area in law where understanding how complex agreements work will not be required of you to serve your client. And it is a kind of a gap. The Cal case is kind of interesting but you really need to know. If you ever say something like this, breach of condition, that's a medical thing, go to a hospital. It's not actually a contract term. And a lot of people have no idea what a covenant is. I mean, is that a reference to when I had to study for my bar mitzvah, or is that something like that? It's a good thing. It's a really important class and to take, and I urge you to do it. So that sort of gratuitous class selection plug aside, I'm going to talk to you today about judging itself and the importance of judicial discipline to a well-regulated Republican democracy. Although this topic has implications for all of us as citizens, it has a special importance for business itself because the predictability and therefore efficiency that results when the law is interpreted in a good faith neutral way is critical to the ability of businesses to create wealth. In that vein, I come to you today to speak in favor of a judicial mindset that favors regular order over the episodic judicial grant of exceptions from required procedural expectations and the need to secure contractual rights at the bargaining table. I come today to advocate that judges use the imperfect tools we have to provide justice equitably, such as standards of review and principles of interpretation, consistently in like cases, and to avoid deviating from them when political pressures or other factors create a temptation for one-off situational departures. I come also to speak in favor of judges retaining our unique and difficult role as part of the government that does something uniquely different from the executive and legislative branches. By adhering to regular order, the judiciary does the most equity because it upholds the reasonable expectations of citizens in a society governed under law and a society that accords a high level of procedural due process and that now enables all its citizens a fair opportunity to participate in electing legislators and the leaders of our executive branches. Now, equity, I was on the Court of Equity for 15 years, and equity emerged in our legal tradition as a gap filler to do justice in a world of unevolved institutions and where not all people were treated the same way in similar circumstances. Equity continues to have a vital role as a gap filler and as a key default protection in relationships where one party is given broad discretionary authority over the property and rights of others. But the equitable impulse is not, I will argue, a license for judges to apply personal idiosyncratic views of the right in cases and thereby enable litigants who have failed to follow procedural rules or to obtain the contract they wanted at the bargaining table to get a result from a court that is at odds with what regular order would have produced. Nor is the power of the courts to review decisions of the legislative and executive branches for conformity with the Constitution a license for judges to strike down rational decisions that the judges personally believe are socially harmful, or for judges to originate themselves constitutional rights without a firm basis in the text or history of the Constitution of our Republic. Judicial action of that kind erodes the ability of parties to fairly rely upon the procedural rules that exist to strike the right balance between fairness and efficiency in resolving cases. Judicial action of that kind erodes the ability of parties in commerce to freely enter into binding and fair commercial arrangements. Most of all, judicial action of that kind erodes the vigor of our republic itself by undercutting the effectiveness and accountability of the elected branches of government by subjecting their rulings to judicial whimsy. Even worse, it reduces the ability of citizens to rely with confidence on the fact that we are a nation under law, laws that apply consistently and not arbitrarily. Not only that, judicial action of that kind taints the judiciary itself by reducing the judiciary to just another partisan actor and the courts of justice to just another forum for a battle of ideological and partisan objectives, rather than a different kind of branch of government uniquely committed to being above the fray and trying to render expert adjudications based on neutral and generally applicable principles of fair interpretation rather than personal predilections. Now, I emphasize today the words mindset and the word role for a reason. I am not here today to debate whether a variant of the originalist or constructivist methods of constitutional interpretation should be adopted. What I fear about many of those who emphasize method is that their emphasis is in fact a cloak for a deviation from the proper judicial mindset. That mindset involves the recognition that the judge's proper role is to give just effect to the intentions of others. For example, those who are elected to legislate statutes or to sign them into law, or those who crafted constitutional provisions, and to give effect to them in a sensible way. Now, giving effect to the written law is a complex endeavor, of course, especially when the provision open for interpretation is not clear on its face or in context, and when intervening interpretations, history, and relevant context have evolved, requiring the provision to be given effect in a society and in a situation that is often far different than the drafters of the provision could themselves have imagined. If in the interest of fair disclosure, I had to confess to any jurisprudential approach myself, I would tend to call myself an adherent to what Judge Posner has aptly called pragmatic realism. As I understand that approach, when the most traditional tools of judging point to a sensible result, giving effect to plain meaning, to commercially understood terms, etc., judges should use them. But most of all, in more difficult cases when there is no clear answer even after applying those tools, judges should engage in a good faith effort, one that involves setting aside personal ideology, as best one can, to make the Constitution and laws enacted by the other branches and accepted by the populace function in a sensible, just way that respects the purposes that those sources of law serve, even when the judge himself might disagree with them. That is, the judge at all times should be mindful that what he is doing is distinct from that which elected officials charged with crafting statutes in the first place do. At all times, he, and I'm saying he just because I'm a he. For students, I don't do he or she. Pick one. You know what I do? I rotate he or she in drafts. It's clear, it's equitable. We do it with hurricanes now. It's why academics should rotate. Every 1 year should be alphabetical order for publication. 1 year should be reverse alphabetical order. And that would be devastating to my friend Lucian Bebchuk, and in a delightfully non-lethal way that we should do for that reason alone. And so, back to the speech. I may not be regressive, but I am digressive. I admit to that. But what I'm trying to say is judges do something different. And what the judge must remember, whether it's a woman or a man or anything else, you should remember that those of us in robes, and sometimes we're a combination of women and men called an appellate panel, that we're charged with trying to faithfully, if necessarily imperfectly, discern how law made by others applies to specific human disputes that the lawmakers themselves often could not have specifically envisioned. That's our job. That's different from the job of the other branches. And in this lecture, I'm going to explore a few areas that exemplify my concern that the public might rightly sense a lapse in the judiciary's commitment to its distinct role in our republic. And I'm going to try to do this tersely in each case, because this is a sophisticated audience, and also I stand between you and some decent chow. I don't know if there'll be hydration too, a hydration opportunity. Now I'm going to begin with their first years in the room, right? And then I'm going to cause flashbacks, but this is actually important because this is the Harold Kohn Lecture. To do this, I'm going to begin with two words that will make you groan. Civil procedure. But civil procedure is incredibly important to the equity-enhancing role of our courts. Since the 1930s, the United States has embraced a system of civil procedure that has elevated full access to plaintiffs and broad access to information over efficiency concerns such as cost and speed. Plaintiffs are subject to liberal pleading standards. Plaintiffs receive fulsome, and I mean that in all senses, discovery. Here's another tip. Be careful about using the word fulsome as if it is praise. It closely. Now, these rules of civil procedure, in them, there's very few procedural snare traps so long as a litigant promptly corrects a prior pleading or asks for more time. There's a lot of leeway for mistakes and prompt correction if you get on it and you ask for permission. And our nation takes legal claims seriously. No nation can rival the depth and breadth of American state and federal decisional law. And it keeps coming. You know, it's like whatever era I was in, I'm always stuck sort of somewhere in the 90s. I mean, it's either in the 90s for me or when I was a kid, when I was the 70s. Senator Carper, I worked for when he was governor the other day, ascribed something to me that we did in 1974. I know it was 1994, but I knew exactly where he was, right? We're all a generation behind. And so I'm always in F second, right? I mean, somebody's always somewhere, right? I'm always in A second, and right? Aren't you, Greg? Like A second. Like, we got freaking A third. We got F third, XX or something, right? It just keeps coming, the law. And so, but we got commentators, right, who cry. I mean, you know, it's great to get excited about something, but that we should set up a new Nuremberg war crimes tribunal because the U.S. Supreme Court has put some rigor in the pleading standards. By gosh, requiring plaintiffs to plead facts that, if true, you have to assume what they is true. And then you have to say, well, does that plausibly support a cause of action? Now, that this sort of modest burden can generate spirited disputes domestically shows just how committed we are to providing access to the courts. And that is my basic point. The rules of civil procedure in the United States are difficult to characterize as unfair when viewed from any comparative international law perspective. The injustices of the American judicial system seem more obviously to me to be the excessive length and cost of litigation in the United States, rather than that it sets up difficult obstacles to the presentation of worthy claims at all. Indeed, the very opportunity that plaintiffs receive to raise claims lightly and seek evidence gives defendants a corresponding chance to raise defenses and explore all possible information, and may therefore boomerang on less well-heeled litigants facing wealthier adversaries. There are, of course, many debatable issues regarding the balance struck by American civil procedural rules and whether there are alterations that should be made. And for example, what I just mentioned, should a plaintiff have to meet a plausibility or a conceivability standard if they are truly different? Should all cases routinely involve electronic discovery? Just how many times does a federal securities plaintiff get to amend under the Reform Act? Now, the last question seems to be answered thus far at minimum 3. One dismissal motion a year for 3 years. That's what we in the United States call litigation reform. For today, though, my intent is not to engage with these less central questions, but to argue that a premise that is both less contentious but more fundamental has a logical consequence. That premise is this: no person of sound reason could claim that Americans' rules of civil procedure are illegitimate in the sense that they are not the result of a good faith decision-making process of a representative democracy that has torn down most of its worst barriers to access. The American approach to civil procedure is one designed to do equity, to take the sport and caprice out of pleading. Debate about its wisdom should therefore be had in the appropriate forum by addressing proposals for change to the societal organs charged with adopting and amending the rules as civil procedure. And that premise is crucial and has an important logical consequence, which is this: I honestly don't understand the continued indulgence by the judiciary of litigants who fail to follow legitimate rules of civil procedure. When a plaintiff files a complaint and faces a dismissal motion, why should he not be obliged to amend promptly at that time, rather than getting to ask for a new chance when he loses and when all the costs of handling the first motion to dismiss have been needlessly incurred? If a plaintiff knows that she must plead demand excusal in a derivative action, knows that a statutory books and records action can help in that process, why should she be allowed, there's a she in there, why should she be allowed to waste the resources of the courts, the defendants, and the other investors of the company, because they're important, the other investors, by rushing to court with a poorly crafted complaint, lose a motion to dismiss, and then be allowed to go back and do what she should have done from the get-go? Why are parties allowed to sit quietly by in the teeth of a summary judgment motion, not seek additional discovery under Rule 56F, which is an option for them, and then ask the trial judge for a do-over if they have lost, or even worse, raise issues for the first time on appeal that they did not raise below? Why do appellate courts allow litigants in a case not involving fundamental rights such as liberty or parental rights to raise issues on appeal that were not fairly presented to the trial court? Why do gun-shy trial judges put their fear of reversal above enforcing the rules of civil procedure in their courts? Adults recognize that rights come with responsibilities. Litigants make strategic and tactical choices in reliance upon the rules. Judges who excuse parties from following clear rules of civil procedure often justify themselves as seeking to do equity, to do case-specific justice. But when judges deviate from fair, neutrally applicable rules, do they really do equity? Everyone who ever coached or played a sport and lost a game knows what it feels like to want a do-over. And then, this is an athletic institution that stole a great basketball coach from Penn, and so it understands that. Has a soccer coach who, when I was a young man, got to watch him play indoor soccer quite a bit. He's good, David McWilliams. So, I'm sure that they want to do a do-over. I'm sure the Penn Athletic Department wants to do a do-over of ever letting Temple get the coach. But, and you think about it after a game, right? If I had only done this, I had only done that. I cut in on beat two defenders. I cut in to goal in a state semifinal when I was in high school. And instead of shooting, I slipped the ball on the ground, and my teammate, who missed an open net. He was not as good a player as I was. I'm not saying I was great, but I was a good high school. I was a lot better at soccer than I was at school. And about every month I think about that. And that happens in litigation, right? In sports, that pass, why did it pass? Your coach, why did I make that substitution? Why did I use that formation? If I could only change it all, I would get a different results. Well, sports are far less forgiving than the rules of civil procedure. Does a plaintiff get to have the court accept all her well-pled facts as true in addressing a motion to dismiss? Court has to what, right? Has to accept all the facts you plead as true. That's yes. Does a plaintiff get to freely amend to address a motion to dismiss? Get to see the other side's brief. And you get to amend. Yes. Do parties have a broad right to discovery in order to prove or defend a claim once they pass go on dismissal motion? Yes. Do parties have a chance to defend a summary judgment motion by showing that the discovery could turn up evidence defeating the motion? Yes. Is there a right to seek re-argument of a trial judge's ruling? Yes. May a party seek to reopen a judgment for newly discovered evidence that could not have been discerned in a timely way with the exercise of reasonable diligence? Yes, right? Does Strine have bangs? Does Strine have bangs? Students, are you listening? No, he has vestigial memories of bangs, but he has no bangs. When I cut in, it was looking good. The hair was flowing. Just should let that fly, let that shot fly. And but my point about these procedural protections is this is what exists. And given that, I don't understand the equity of excusing litigants from compliance with these generous rules. The inequities that result are obvious, but seem to be lost on judges tempted by situational sob stories or afraid that appellate courts will be, because that's also an important thing. These inequities include, but are not limited to, forcing parties who have played by the rules, shaped their strategy by the rules, and made tactical and strategic judgments by the rules to suffer a do-over or even worse, an outright loss based on foul play. That is, an argument or issue or evidence that was not fairly and timely preserved and presented. reducing the predictability of all litigation, thereby generating more disputes and costs as litigants believe they can game the system, reducing our busy trial courts to moot courts, and diverting scarce judicial resources to non-binding run-throughs where litigants can rehearse their claims knowing that they get a second chance later on appeal, making real the claims of America's international competitors that our legal system is out of control and indulges parties who wish to enmesh opponents in years and years of costly litigation practice as an economic weapon, pricing less affluent litigants out of the system by creating a system that lacks certainty and timely procession to closure, thus advantaging litigants who are less price sensitive, and making trial judges gun-shy to enforce the rules because bending the rules rather than enforcing them is the safe way to go on appeal. Equity demands that all litigants follow the normal rules. Otherwise, courts will be unable to afford everyone the same equal treatment. Litigants seeking one fair shot will have their chances diminished because others have exhausted the system's capacity for patient consideration. The more adamant and resourced a litigant is, the more he will demand. That is not equity. It is the exact problem equity arose to address. Rather than equitable rules of neutral application governing all, certain litigants are allowed more justice than others, necessarily rendering their litigation adversaries recipients of less than ordinary justice and undermining the overall fairness and efficiency of our entire system of justice. Doing equity requires judicial discipline, self-restraint, the willingness to hold litigants accountable for complying with rules of general applicability. Situational justice is not equity. It is the palliative breakfast mush of the timid conscience for judges unwilling to do the hard work of equity by upholding fair rules of civil procedure of general applicability. By refusing to excuse the failure of parties to play by the rules, courts promote equity by demonstrating that the judicial system provides equal treatment to all and is not just the playthings of litigants with the resources or the talents to sell a sob story to secure special treatment. Now, I'm now going to turn to what I see as an analogous viral strain. When I wrote this, it was pre what was going on now, so I apologize for bringing something painful to mind. But this viral strain is a related deviation from regular order that occurs when judges employ what I call the MSU doctrine in lieu of adhering to accepted traditional judicial norms of decision making. Rather than sticking to the standard of review or other interpretive principles applicable to the type of case before them, the judges loose themselves from these constraining binds and free themselves to deliver what they no doubt view as case-specific justice. They, quote, make stuff up, end quote. Now, depending on your mood or frame of mind, another word than stuff, might pop in your head. But precisely because judges have shorn the constraints of applying neutral principles of decision-making, they necessarily introduce the potential for inequity by treating some cases as special, as involving a reason to deviate and reach a result that cannot be explained in terms of generally applicable standards that would govern similar cases. Now, admittedly, standards of review and other interpretive principles are flawed, imperfect tools. That's necessary. We're human. Humans are not perfect. There are some that claim that they are, and be scared of them. But I actually think if you actually have a reverence for something greater than recognizing that you're different than the something greater by having a certain modesty about yourself and your own certainty, is one of the most gracious ways of showing respect to the Creator. But that's also a digression. But these principles of interpretation, the things that we use to decide cases, the traditional tools, and they're not perfect, but they do reflect something that's important, which is the good faith struggle of many jurists facing many different cases over many years to come up with sound methods for addressing certain types of cases or legal situations in a reasoned, balanced way. Indeed, these standards often have built-in safety valves to ensure their equitable application. when these neutral principles of decision-making are forsaken or distorted in a so-called hard case, judicial whim rather than genuine equity dictates the outcome, rendering the law both less predictable and less fair. I'm sadly confident that the MSU doctrine can be viewed in action in more than a few areas of law. I'm going to mention three now. One involving students' contract law, another involving corporate law, and lastly, most worryingly, it's on display in public law, where there is a judicial willingness in all these areas to override the judgments of the political branches by calling their actions arbitrary and capricious, or by originating new areas that are now off limits to legislative action by dint of judicial fiat. In public law, that's especially troubling because these decisions often ignore generations of regulation and settled conduct by the political branches, which were often approved as lawful by prior judicial precedent. Many of these recent decisions read like one side of a congressional debate, where an appellate majority, convinced of its own policy wisdom and deep contextual understanding of things like the political process, simply declare the contrary policy reasoning of a legislative or administrative body unlawful, with no firm rooting in constitutional or statutory text, legislative history, or judicial precedent. Now, I'm going to begin with the more profane categories that involve laws addressing the hurly-burly of a capitalist society. A context where judges' personal predilections to do situational justice presents a constant danger of inequity is when judges are asked to address claims that a commercial party's conduct, despite not being prohibited by the express terms of a detailed, lengthy contract, is instead prohibited by its interstices. And I mean, that was pretty good, right? I pronounced interstices in front of a daunting audience like this. Just spot on. Now, the fact that parties can enter into binding, predictable arrangements called contracts is a vital enabling factor for wealth creation in our society. When sophisticated parties take months to spell out their obligations in a detailed, complex agreement, courts should be reluctant to improvise by indulging claims based on the notion that a party to a 75-page, single-spaced agreement did not breach an express term, but somehow violated a duty implicit in that dense draft. Putting to the side the need for a new presumption against the existence of microscopic interstices in single-space drafts, a judicial willingness to lightly accept such claims has several negative consequences that are, in my view, inequitable. For starters, when judges imply duties that are not set forth in carefully constructed contracts, they reduce human freedom. When an arm's-length agreement specifically addresses what parties cannot do in excruciating detail, the conduct it does not address is that which remains open for free action within the bounds of positive law. Judicial additions to contracts that restrict human freedom subject commercial actors to arbitrary incursions, not justified by any lack of capacity by the complaining party to have gotten a written contractual prohibition in the first place. Furthermore, such judicial free-ranging in the name of situational justice raises the cost of contracting by requiring parties to say not only what they mean to address and prescribe, but also to say what they do not mean to address and prescribe. When you get the written draft, that'll be easier to think, but it's a deeply profound point. It's kind of Nobel stuff, I think, really. Now, beneficial arrangements may be eschewed because of a fear that courts will imply more than parties put down on paper. And by the way, students, a verbal agreement, when you say a verbal agreement, you are not distinguishing between a written agreement and an oral agreement. A verbal agreement is one in words. A nonverbal agreement is like you both had to, it's chemistry that does not need to speak its name. It's the kind of thing we don't want to talk about now, be politically incorrect to think about, but let's just say a 75-page written agreement would traditionally be a verbal agreement. The only way it would not be would be if it was 75 pieces of paper and it somehow were blank and somehow reflected an understanding that was not, I don't know. There could be, I don't know, because I think symbols would be considered, this is Chomsky kind of stuff, right? But would probably be considered words unless one were being very culturally judgmental, in which case, I would have to part company from that unenlightened philosophy. But my point about when people put down, when they actually take the steps of putting a verbal agreement down in writing, is that you might not do that and enter into a valuable kind of arrangement like that if you fear that the court will imply more than you meant to agree to. If you think that the court is going to hold you to more, look, I agreed to 30 pages of restriction on my freedom, but now if the court's going to go and imply a bunch of other restrictions, I may not enter into certain kinds of contracts. And I think by being disciplined in enforcing contracts as written between sophisticated parties, the courts actually enforce real equity by requiring parties to restrict another's freedom of action at the right time, while at the bargaining table, and by permitting people in the marketplace to proceed with the confidence that they will be subject to only those duties specified or clearly implied by the actual language of the party's bargain. But there's a lapsarian tendency in the judiciary to expand the implied covenant and to use it as a license for judges to reach what they deem to be a case-specific just result, to enforce the contract as the trial judges or appellate panel's heartstrings believe it should have been written. Jurists subject to this tendency also tend to freely gut or minimize the effect of contract provisions, such as non-waiver clauses clearly requiring any waiver to be in writing, or non-reliance clauses saying that the parties disclaim any reliance on any non-contractual representations and warranties. And my favorite thing is when they call courts slough off core contractual terms as mere boilerplate. Now, this is an extremely strange type of reasoning that relegates to the category of to be ignored those contractual provisions so fundamental. That's what here's the definition, students, of boilerplate. Contractual provisions so fundamental and important that they tend to appear in substantially similar form in all contracts dealing with the subject matter. Oh, boilerplate, right? Oh, like, that's the core crap. Just ignore that, right? That's why it's boilerplate, because it's so essential in that commercial context that some form of it tends to appear in every contract. You can't just slough that off, right? That's the essential stuff. But courts do that. Now, regular order and contract interpretation, a consistent adherence to settled interpretive principles focusing closely on the meaning of the contractual words, allows all parties a fair opportunity to make mutual beneficial bargains on predictable terms. And when judges twist interpretive doctrine to shape case-specific results, they don't do equity in its true sense. They give certain parties more than is due to them, and they undermine the reliability of voluntary contracts for all. Now, that's also true in the pure corporate law context, to which I now turn. Even when judges are called on to exercise equity jurisdiction in its core form, such as determining whether a corporate fiduciary has breached her fiduciary duties, judicial discipline in the form of a desire to deliver a result in a particular case can lead judges to not apply the same standard of due process to all cases. In other words, they make stuff up. The equitable overlay to American corporate law is part of its genius. The key to allowing directors to manage corporations under broadly enabling statutes rather than highly prescriptive codes. But precisely because so much of corporate law involves judicial articulations of fiduciary duty principles, judges caught up in the moment sometimes mistake their role, forgetting that any condemnation of a legally permissible act on the grounds of inequity requires a finding that a fiduciary breached her equitable duties in a specific manner. Judges moved by the moment or feeling political pressures, yes, judges feel political pressures, untether themselves from that disciplinary prerequisite and occasionally spew forth oxymoronic statutes of judge-made equity law. per se rules of equity that prescribe in all circumstances conduct that is specifically permitted by statute, regardless of whether the directors have breached their fiduciary duties, narrow the freedom of action granted by the legislature, and undercut the reliability of corporate law. With the decline of defined benefit pension plans and the resulting dependence of ordinary Americans on the success of the public equity markets, corporate debacles have become more politically salient than ever. Business unavoidably involves risk, and the need to proceed in the face of uncertainty is real. Even excellent managers can make decisions that go way wrong. Before many of you were born, there was something called the New Coke. The New Coke was not well received. Had the board of directors and managers who adopted the New Coke been subjected to damages liability, that would not have made Coca-Cola stockholders better off. The same management and board that made that bad decision made that corporation into a truly global powerhouse. The genius of the business judgment rule exists to constrain people like me who wear robes from second-guessing disinterested business decisions and therefore stifling the willingness of corporate fiduciaries such as the Coke board to innovate, to be creative, to be bold. That's the essence. That kind of innovation, that kind of risk-taking is at the core of what often creates new sources of economic growth. When judges forget that and bend concepts such as gross negligence, financial interest, or good faith because of the potential unpopularity of adhering to the business judgment rule in a specific case, they undermine the wealth-creating basis for the rule. Likewise, when judges forget that the equitable overlay exists to protect stockholders from overreaching by fiduciaries and does not exist to protect fiduciaries from the exercise of electoral and other rights by stockholders, the entire framework of corporate law is turned on its head. Instead of using equity as a cautiously employed and focused shield to protect stockholders from directors misusing their broad statutory powers for improper purposes, equity becomes a weapon against the stockholders themselves, wielded by a judiciary that is unconstrained by the electorate and revealed by its own actions to be unconstrained by the discipline of adhering to the traditional structure of corporate law. Real equity demands that legally authorized actions by directors not be condemned as inequitable unless the directors have found to have breached their fiduciary duties of loyalty or care on the basis of equitable principles that the court would apply in all cases. Real equity requires that stockholders be able to exercise their electoral and other rights unless those rights conflict with a statutory, legislatively made, or contractual party-made restriction on that freedom, not an equitable judge-invented restriction. You'll be glad to know I come to the last category, which involves, and to students, some of you are first years and might have more resonance because you haven't had corporate law yet, but this is the dangers to societal equity that exist when unelected judges view themselves as having a broad license to second-guess policy decisions made by the legislative and executive branches of government. Now, there's little doubt that in some important moments, our judiciary has played a vital role in promoting a more equitable society by, for example, declaring de jure racial discrimination in public schools an equal protection violation in 1954. And in fact, one of the proudest moments in the history of the Delaware Court of Chancery was the decision of Chancellor Seitz who said, in one of the cases that he was the only state court judge in the country who ruled for the black plaintiffs in the school desegregation cases. And he said that separate but equal was wrong, but he was a trial judge and he couldn't overturn it, but he knew what equal was, and they were sure enough separate schools, but they weren't equal. It was a case, there was one vote that didn't go that way, and that's why it wasn't called Belton versus Delaware versus Brown versus Board of Education. But that's a digression. But it relates to the fact, the reality is that the courts have done some good things, but even considering the reality, of what the courts did, you have to realize that it should have been difficult, if not impossible, for anyone in good faith to linguistically reconcile with the 14th Amendment of the Constitution, racial segregation in the first place. a point that Justice Harlan made years before Brown. But I think we can all agree that the judiciary's all too belated enforcement of the plain words of the 14th Amendment helped make our republic more legitimate by for the first time giving all citizens a fair chance to elect their representatives and all citizens equal protections of the laws. Of course, had the judiciary had the courage and good faith to enforce the clause as written in the first place, rather than hiding behind a morally and linguistically perverse doctrine that was waiting for George Orwell's birth to be labeled properly, separate but equal, then our black citizens may not have had to endure another century of oppression. Well, my task today is not to revisit or re-argue that shameful part of our past, but to discuss where we are now. And where exactly is that? In a nation that has taken, happily, major and long overdue strides to rectify its past practice of race and sex discrimination, and where remaining areas of discrimination, for example, against people who are gay, are being rapidly addressed by the political branches themselves. What is strange and disturbing to me, however, is that with a more legitimate Congress, with more legitimate state legislatures, and with more legitimate executives, the traditional judicial reluctance to upset the decisions of the political branches, rather than being reinforced and strengthened by the sounder basis for deference that now exists because of the enfranchisement of citizens regardless of sex, race, or ethnicity, seems instead to have been relaxed and in some cases abandoned. Respect for generations of prior judicial decisions, respect for the political branches, and respect for the public's ability to order their affairs in reliance upon settled interpretations of constitutional and statutory text are lightly put aside by judges confident that their novel view of things should supplant the decisions of those accountable to the electorate. I confess to being worried that the more constant use of the MSU doctrine in public law is beginning to generate justified skepticism on the part of the public that judges are just another form of partisan political actor, but garbed in robes that cloak and obscure their true agenda. Why do I say that? In public law cases involving the business law area alone, the last 5 years have seen a number of eyebrow-raising decisions that seem to involve judges willing to advance their political policy preferences over the determination of duly authorized legislative or administrative agencies. The ease with which these judges can invent, and I do mean invent, originate in the sense of a novelist, if you will, new constitutional rights undiscovered for 200 or more years, determine that the decisions of a specifically empowered administrative agency are arbitrary and capricious despite evidence of years of study of a voluminous record, or tell an enforcement agency how to use its authority, is disconcerting to me. In some of these cases, the policy end of the judge is one that I share as a citizen, but that does not mean I find favor with the judicial decisions. To the contrary, it matters immensely who makes a decision in a republic if we are truly to remain a republic. Judges who do not show respect to the legitimate authority of the legislative and executive branches threaten equity in a fundamental way by undermining the rule of law itself. Policy battles should be won at the ballot box in the electoral and legislative process. The policy whim of a momentary judicial majority is not justice. It is caprice and the opposite of equity. If a judge is not inclined to defer to the policy determinations of the political branches in the absence of any failure of equal participation by all affected citizens and to resolve all doubt in favor of upholding their judgments, he makes himself into an unelected and unaccountable lawmaker, willing to dictate to his society on the basis of his own preferences. Such a mindset enervates the strength of our republic, making citizens skeptical about the fairness of our system of justice, leading them to view political participation as a waste of time because the judges will do what they want, and leads them to see the judiciary itself as just another bunch of self-interested partisans. The judicial role is a unique one. That role necessarily involves upholding the ability of litigants, including the government itself, to take action that the judge himself may not view as ideal or even moral, but it must be upheld when that action is not prohibited by positive law, when interpreted using principles that the judge would apply in all like contexts. The judge's role is to neutrally enforce the rules of the game of what is now an essentially open and inclusive participatory democracy. When judges adhere to their role, they do justice by each and everyone, which is the essence of equity. When we adhere to our role, we emphasize the central ideal of our republic, which is that those directly elected by the citizens are the primary lawmakers and are accountable for their wisdom to the electorate. The judicial pursuit of personal policy goals contradictory to those set legitimately by the right political branch players is a misuse of authority, a subtle form of tyranny of its own, corrosive to the fundamentally equitable vision that animates our form of democracy. So I will finish by indicating that regular judicial order, the regular judicial mindset, may not always be popular, and it's not particularly sexy. But it's vital to doing real equity in a Republican democracy. It's also critical to wealth creation. And we owe a duty to you when we wear robes to remember what the robe symbolizes and to remember the power that we are given and what it involves and it does not. And I appreciate your patience with my remarks and for all being here. And it's an honor again to present this very special lecture.